drink some more?
Yes, absolutely. All right, so everybody's been working on their binders. I see some binders put together here. So yeah, we got a chance to see yours. Like if you guys don't mind, I know it's not 6 o'clock, but if you're ready, let's giddy up and get going. You know, so what I thought we might do is just kind of go through. Maybe you guys will have some ideas with each other, and I'm going to pick on Victor first, and just walk us through your binder. What is it that you have in there? How have you labeled yours? So on and so forth.
Pretty much broke down what was already in the packet. So I have my facts of the case, I have my legal authorities separated, I have my jury instructions, and I have my cases.
Those are cases for the argument, for the oral argument.
Yeah, all the cases are here.
Okay.
And I split up my witnesses by our witnesses and defense witnesses.
Mm-hmm.
So then I wasn't sure if to put them in order by first name or last name.
It really is a personal preference. You know, I know Dean Dolan talks about he wants all of his witnesses together alphabetically. I'm assuming he does them by last name. I like to break mine down by size, right? I know who I'm calling. They're my witnesses. So, and everybody else is a potential witness at that point, because I don't know who the defense is calling. So with regards to me, my presentation I keep separate, and then I have a separate section. But there's nothing wrong with throwing all the witness statements in one area, and just as long as they're organized.
Yeah, put witness tab, and then inside the witness tab, I split all the witnesses off individually.
Okay.
And then we got my exhibit tab, and then here's for all the extra stuff in the back. I separated it out, but I don't know what's labeled, but I just put index, and I put like all the samples and all the the procedures for presenting a mock trial and all that stuff in the back.
Mm-hmm. Do you have an objections tab?
I have extra tabs in the back for when I gotta make some new tabs. So yeah, I haven't labeled it, but yeah, it's here.
Well, you have the objection section. You just
I just don't know what to label it because it says summary of allowable. It's like check that.
Okay.
I can put a label on it right now.
Vincent, how do you have yours broken down?
I have the charging document, the jury instructions, and the trial brief for the first 3 tabs. The opening statement, and then I have all the witnesses. They're done by first name, except for the doctors. They're doctor whatever, but they're still alphabetical. And then I have an objections tab, and then the closing arguments tab. And then within the trial brief tab, I'm going to put Will's response, and then once they get a chance to write up a reply, I'm going to get that out too.
Okay, probably not a bad idea. Make sure that it's probably not a bad idea too to have like a either a separate exhibits section or
in my witness tabs, I have each of their witness statements in their tab, so their statement in their tab, and then I also have any exhibits that I feel will go with that witness in their tab. So I have like multiple copies of the floor layout and everything like that in with the different witnesses that I want to use it with and stuff like that.
And it's probably a good idea to have multiple copies of exhibits, because let me tell you what happens. You know, sometimes you hand your exhibit to the witness and they're looking at it and they haven't laid a foundation for it yet, and courts generally don't like you standing up there questioning the witnesses too long. Okay, counsel, get back to your podium. So sometimes you're going to want a copy for yourself to question them on. Now, of course, if you've got an Elmo at some point, once you produce it, Yeah, right. You're going to be talking off the same reference material, but until that point, they may have one, you may have one that you're going to be needing to use to walk them through. So I always like to have multiple copies, at least two.
That was gonna be my question. I guess that's how I did it. But yeah, I was like to make copies of the exhibits and then have it, as long as it's organized, have the same exhibit multiple times in your binder.
Well, I always like to have two. So what I always did is I had an exhibit tab that had in my exhibit list with all the exhibits, and I would give that to the clerk. They would, pre-mark them. Generally, sometimes for some reason clerks didn't like to pre-mark them, which is a pain in the butt because then you got to go to the clerk, get them to mark it first, and then go to your witness. But most clerks wanted to pre-mark them, and then I kept them in the witness tabs as well. So as I'm walking through my exhibit list, and I always organize my exhibit list based on my anticipated presentation. So my exhibit number 1 was what I anticipated using first with my first witness, second witness. However, right, I didn't organize my exhibits based on, well, these go together, but they're going to come in at different times from different people. I don't want to put them 1 and 2. I put them 1 and 20 if I've got other witnesses filling that time. So I always wanted it to flow. Here's my number 1. Here's my number 2. Here's my number 3. Because as soon as you say, oh, and here's, item 17, there's no issue with the court and with the clerk and with the reporter. They're going to put down whatever you say. But the jury's going to be wondering, hey, you just jumped from 3 to 17. Why?
All right.
So I always like to keep mine in order. And how I had my case laid out. This is going to be my presentation order. This is what I would like to see my witnesses, the order I'd like to see them in, and then go from there. And then I always had 2 because I had the one for the clerk, which was my official set. And then I had another copy that I kept within each witness tab. And well,
so sort of a similar layout. I have the charging document, and then I have the 148.3, and then the 422 in separate tabs. And then I have the pretrial motion, the people's opposition, and the reply. And then I'm going to put the whole fact situation, it's like 4 pages, whatever, as a separate tab. That way I can just reference it quickly. Then they have the simplified rules of evidence, basically like the objection pages.
mm-hmm.
And then I'm going to break out my legal authorities, into, so in addition to the larger tab, I have these number tabs. I have 2 sets of these. So I'm going to do that for legal authorities. And then I'm going to have an exhibit tab. And then it also, or they're also in witness files where applicable. So I have so the next thing is 10, the witness statements are all going to be together. And then I'm going to have a separate tab for each witness. That's going to have like what I expect, their statement, and the applicable exhibits, like just for them. So in addition to having them each in their own tabs, I have like a witness prep almost,
Right.
And so that's 8 tabs. And then I have the opening and closing.
Okay.
So I did have a question about the fact the statement of facts or whatever that they give us at the very beginning of the packet.
Mm-hmm.
I used that, and I know Will did too, probably only because I did it in the motion. Are we going to be using that as like a police report type situation? Or are we going to be able to
We have the police statement.
reference that, or because it's technically, I guess it's only supposed to be an overview, but there's facts in there that none of them talk about in their that nobody talks about in their witness statements, but it's not technically like a witness statement or a police report. And I was just wondering if and how we would use that and how we would reference that.
Well, here's how I would anticipate using it. Feel free to use it by way of questioning. Just understand if your witness isn't familiar with it, you're going to get a, no, I don't remember that. To the extent you can take that summary, because my recollection of the summary is it doesn't necessarily tell you where that information came from, right? So if you then try to refresh somebody's recollection with it, and they're like, I don't know what you're talking about. No, that doesn't refresh my memory. Okay, then you're kind of stuck. So unless it's a really major point, you know.
Really, the only major thing that's in it is Sawyer's response to Reagan's comment, because none of them actually say what his response is in their police reports. It just says, it alludes to it as far as, I think Reagan's is like, well, you saw how he responded to it. He wasn't even scared. And then Sawyer was, I responded to it, but only in that way so that I could keep up my image. But nobody physically says, this is what he commented back on it.
Right.
And I also don't think...
Is that on the exhibits? It's on the exhibits, though, right?
No. The only screenshots are the text-to-tip and the food ordering screenshot. They don't actually give you a screenshot of the comment and the response.
Okay. Then I think it's fair game to question them, but just kind of keep in the back of your mind, right? Don't lose focus when they don't give you the answer you want. Okay. And then when you try to refresh their recollection, they don't, like, I don't remember that.
Honestly, I'm probably going to bring it in from the very beginning in the prosecutor's case in chief, because I'm not going to want you to bring it up. You know, I'm going to want to go through.
Yeah.
I want to just go through how he actually felt. You know.
Yeah. So should we drop like a fake script? Is it?
I don't know. I mean, I guess you could just skip it, you know, and then go right into how he felt at the preliminary hearing, how he described what he felt, and make him figure it out. Maybe that's what we should do. I didn't think about that. Yeah. I don't know.
Okay. Well, just some thoughts that I have to help you guys out with regards to how you might want to complete your trial bikers. Okay. You're gonna want to make sure you have your aids to every component, right? For example, if you have a summary of your arguments that you want to make with regards to your motion, and you want that in an outline form, or you want to have your key points and the authorities that support it underneath it, right? You're not going to want to have your motion in front of you trying to flip from page to page to argue it. It doesn't make for an easy argument, because when you're doing your argument, what most of the time happens is the court's already read your motion, and they'll say, counsel, you know, what do you have to say? And you'll start saying something, and the court will hit you with a question, right? And then you're going to need to be able to think on your feet and respond to the question, and then be able to come back to your argument where you were and continue on. And then they hit you with another question, right? And it may be taking you out of order. So you're going to want to have some reference point that allows you to stay focused on the arguments that you want to make. Okay? And with regards to your opening statements, your closing arguments, things like that, you want to be putting some thoughts in those, and those want to be prepared and in your binder before you ever start the trial. Okay? So whatever it is you're going to need to get you through those sections, make sure that you're you're working on those. Okay? So the organization is good. These are good starts, but now you've got to start filling it in as you prep for trial. And as you go through your witnesses, find your way that works. Like I said, I know very successful attorneys that write out every question. I don't, but I know people who do, and it works for them. So what I would encourage you to do is spend some time with your witnesses, because it shows if you try to wing it. If you try to just step up there and say, you know, I'm just going to ask questions. I kind of know what I want to get to, so I'm just going to ask them on the fly. It doesn't come across as smooth. Your language isn't as on point as you would want it to be, and that takes prep ahead of time, right? And so spend some time with that and make sure you've got whatever outlines you need in place. Here's the issues I need with this witness. Here's the exhibits I want to use this witness, and be able to call them and accomplish what you want. What you don't want to be doing is having a witness on the stand and you have their fact statement in front of you, and you're like, well, then what did you do after that? And did you say this? And did you tell this person that? And right, because you're just, it's not gonna, it doesn't flow well. So presentation is a key, right? Keep in mind you're getting graded not just on your content, but on how you present the content in trial.
So I have a question about how are witnesses typically called? Does the defense get one, the prosecution gets one?
But we do our whole case, and then they do their whole case.
A whole
Yeah.
case and the whole case, and then we direct our witnesses and cross theirs?
Correct.
You do your whole case, and then I do a motion for non-suit saying that you guys have improved your case. Down.
11:18.
Okay.
11:18.
If we do that, can we go home early? Is that how that works?
The shittier you guys do, the better it is for us to go home.
So, you know, but you want to, you know, having the layout is one thing, but now you've got to start filling it out with your component. Okay, what is it you're going to do? How is it you're going to present this case? And how do you want them to tackle it? Make sure you have points that you want to get in and out with on cross-examination, right? I know we've stressed this before, but you do not want to just let the witness repeat everything they just said on direct examination. But you see witnesses, I mean, lawyers do that all the time. They don't know how to cross-examine, so they basically have them go through the whole story again, but with more pointed questions and a little more attitude and like, so you're.
You make it sound scary.
Yeah, so yeah, just because you're putting some emphasis on this doesn't mean it's coming across that way. Short, simple, direct, leading questions is what we want to see on cross. Okay, we do not want to see you asking open-ended questions and letting the witnesses just have a field day. Okay, your point is to get your story across.
There's a bunch of yes or no questions. Like
Absolutely.
Is this what I say?
Absolutely.
That's
And be
what really
prepared. I don't know how these guys are going to be, right? But they're probably being trained on how to not answer yes or no, right? And you're going to get that in real life. So be prepared. Okay, how are you going to handle it? Right? There's different ways, and we've talked about the tactics you can use to overcome that. I always wanted to overcome that with the witness. I never wanted to ask a judge to say, Your Honor, they're not answering my question. Can you help me? You know, and I think it's more persuasive when you handle it yourself. But you gotta, in order to do that, you gotta know, here's the question I asked, right? And it's gotta be a sharp question, right? That it's obvious they didn't answer, right? If you ask this, you know, rambling all over the place kind of question, and they start rambling, it's hard for you to say, well, that's not answering your question. Then the judge is like, what was your question? You know, but some of the best ways to pin them down, right, is to re-ask your question again, right? And it only takes generally 2 to 3 times, and the jury gets it. You know, you're not answering my question.
So worst case scenario, how do you handle a hostile witness?
Well, if they truly are hostile, right? For me, I try to make it as matter of fact as possible. If I'm dealing with a witness and I'm examining this witness, and the judge is up here, you know, and they're hostile and they're not answering my questions and they're not doing whatever, I just ask the court. I'd like the court to find this witness hostile, or permission to treat this witness as hostile, right? No elaborate argument or because the court's seeing the same thing as well. And a lot of times I don't even look at the court because I didn't want to leave that perception. Hey, this is just a matter of fact, you know, permission to treat him as hostile. Yes. Boom. And then you just keep going.
So what changes when you're treating a witness as
Then you get to lead them. Right? If you're cross-examining,
They're already hostile.
Yeah, they're already hostile.
Oh,
They're
so
presumed hostile.
If it's a direct examination and they're hostile,
And they're not answering your questions.
then you can treat them, and you ask leading questions.
Correct. Correct. And like I said, after probably about 3 or 4 questions, the judge will pick up on them not answering. And, you know, I know we've stressed this before, but we can't stress it enough. Spend some time with your closing argument, because that should give you the formation for what it is that you're going to present. If it's not an issue you want to argue on to the jury, then don't make it a hill you're going to die on during your presentation. If it's not a big point, who cares? Let it go. But you have to make sure that you are able to argue the facts that you want to argue. So get those in, right? That's your presentation. I want in the things that I need to allow me to make the arguments I want. And if you haven't thought about what you want to argue, then you're going to do the kitchen sink technique. And you're just going to say, well, let me just let everything in. Well, why'd you let that in? That didn't help you. That actually hurt you. Well, I don't know if I want to argue it yet or not. Okay? Right? You guys have the ability to put that time and effort in now. So, you know, spend some time with your closing arguments. Use it to form the basis of how you want to question and cross-examine your witnesses. Use that as the basis of how you want to lay the foundation for your opening statement, and lay any themes you want to carry through. So we're not here next week, right? But we're here the week after. So what we would like to see the following week is pretty much a completed binder, okay? Including all of your work, okay? Don't want to see a tab that says opening statement and it says freestyle. right? No, that's right. We want to see the work that you're going to put into how you're going to give your opening statement. Okay, and we want to see some form of individualized organization with your witnesses, your questioning, your cross-examinations, to demonstrate to us that you have thought about, okay, this witness for the other side and how I want to attack. Here's the issues I want to make with this person. Okay? Lay out your closing arguments. You guys have time to write them out if you want. Doesn't mean you have to deliver them that way, but I noticed when you gave your arguments, during the practice portion, for the most part you wrote them out. Victor, you were more of an outline, but I mean, it's you and Will.
That was nearly verbatim.
Yeah. However, you're going to be comfortable, but do that in the next 2 weeks, so that when you come, all you're really doing at that following week is fine tuning. You're just tweaking it. You should be able to be ready to come in, and I'm going to be ready for trial in 2 weeks with my minor. Okay, and I think we may have shared this with you. Maybe we didn't. If not, well, I'll make sure you know it now. The expectation is when you do your trial, you suit up. Okay, you come in, you look like lawyers, and so suits, ties, all the fun stuff that lawyers hate to wear. If I had known that I got to not wear a tie in civil, I would have done that a long time ago. I wore ties every day. I see the partner. I'm not there with my partners just yet, but the partners where I'm at, they're jeans and t-shirts and shorts and flip-flops, and if they don't got cord or they're not meeting anybody, they're about as casual as they come. Okay.
That's how it is in my office too.
So I'm not there yet. For the most part, I'm still slacks and a button down every day. But when you have court, and especially if you have trial, dress up. We want to see that on the 6th. So not in 2 weeks, but in 3 weeks when you come, come ready, come prepared for that. And I will probably even wear a suit as well, so that my partner doesn't lose those points, because they look over and say, "Man, you're working with." Then you tell this guy to wear a suit.
So what is your opinion on suit colors? Because Drucker gave us a whole spiel on different color suits.
Here's what I believe. Okay, and then it really depended on how long I was going to be in trial. Okay, if I am in a long trial, they're probably going to see me wear multiple suits, probably the same suit more than once, and just mixing it up with different shirts and ties and whatnot. I think in that scenario, suit doesn't matter, right? Because they're going to draw an impression of you over time. But if you've only got them for a few days, like, hey, this is going to be a 3-day trial, 2-day trial, yeah, it matters. So, I would always want to look sharp, initial impression, right? I think that's always more important. I always dressed up for my closing argument, but my thought is, by the time I get to my closing argument, hopefully they formed an opinion of me such that how I dress isn't going to matter. Okay, and I've seen defense attorneys that dress very nice, and they're just not good attorneys. So I don't think it it matters. But you know, you come in. I've seen attorneys too, who, especially private defense attorneys, that would come in and you know their ties up to here and their shirts untucked and it's just, they just look like a mess. Well, that's the impression you're giving the jury. As far as colors, you know, the standard, you know, is you know, for closing argument, dark suit with you know, some people would say the red tie. To me, that's cliche. But I don't want to wear a navy suit with a red tie for my clothes because that's what everybody's wearing. So I tried to steer away from that, but I typically wore a darker suit because I think that gives the visual of it being more serious, more, you know, than coming in with you know, a lighter color suit. Typically, when I started out, when I'm picking a jury, you know, I typically wore lighter suits because I wanted to. I got a different goal there, right? My goal isn't necessarily to impress them with, wow, look at how nice he dresses. It was much more to get them to like me, get them to trust me, start forming that initial bond. So there's studies that say how to dress. I never really paid that much attention to them. So, but I would say dark suit for, and if you got a 1-day trial, then, you know, I would wear probably my nicer suit for a 1-day trial. But
So I shouldn't wear the plaid suit.
no, plaid, you know, seersuckers, you know, probably not what we're going for here. But
Straight up like Dumb and Dumber, you know? Yeah.
Yeah, but it's however you got to be comfortable. So I know for me, over the course of my career, you guys may find this hard to believe, but my suits and how they fit me fluctuates. You know, sometimes it's like, yeah, the suit's fitting good. And sometimes like, I feel all stuffy in it. If I don't feel comfortable in it, I'm not going to wear it, especially for a closing argument. So, you know, you got to be comfortable in it, and it's important that you are. Otherwise, if you looked all stiff and confined, the jury's going to see that too. So, I don't know if that contradicts, but I'm not one to follow the rules. Like I said, I know I've shared this probably 100 times, but I still to this day give arguments with hands in my pockets. I just do, and any number of people say, "Get your hand out of your pocket. Get your hand out of your pocket. What are you doing? Why do you got your hand in your pocket?" It's how I feel comfortable. You know, so if I ever lost a trial because man, the guy had his hand in his pocket, you know, I think there's something wrong with with the jury. So I've never been one to necessarily feel you've got to follow the standard. Here's what everybody needs to do. You know, I think you need to do what works for you and what you're comfortable with, and you know, that would include suit color. Wear something that's going to fit you and your personality. You know, if they get to know you and over the course of the trial, and they have this opinion of you, and then you wear this suit that just doesn't match. Like I would never be able to pull off, these fancy designer, suits. I don't own any Armani, anything like that. But I know people that own very fancy suits and they wear them. I never have. And I've never had any jurors complain or even comment, you know, you might want to dress differently next trial. So.
This isn't New York, you know?
Right.
Like, it's not that, people aren't judging you really that much around here.
No.
About that, I mean, yeah.
I'm judging you, Will.
It's because you're from New York.
So, what other questions you guys
Vermont.
have before I send you off for 2 weeks?
Yeah.
Everybody knows that they're coming in with a complete, filled out trial binder next class. So 2 weeks from now, right?
Sounds like a plan.
Okay. If you got questions for it, now's the time to ask. I mean, you can send us emails, but
You can't send my partner emails. My partner.
There you go. There you go.
And I'm going to tell you two, both of you. Okay, he doesn't have to worry about it. I don't know if you guys are objecting, but I'm objecting.
Okay.
So I'm just telling you that right now.
All right. Fair enough.
Expect on witnesses that I'm dealing with, I'm going to object.
So I'm gonna work really hard and write more questions.
So you know, be prepared.
It'll be a good experience.
You know, I thought, I mean, just last year, I thought it was a fine example. Right? Aaron was by far our best trial presenter. And what I deemed him on the most was he had no idea how to respond when I objected. He lost, you know, it was a witness he was directing and he wanted to get stuff in and I'm objecting and he didn't know how to get around it. So, and he let some frustration show when that happened. Don't ever lose your cool. I mean, like Dean Dolan says, you know, court will rule against him and he'll smile. Thank you, Your Honor. Just move on. Move on. If it's that big a point, you better know how you're going to get it in, right? That's part of your witness preparation. I know when I've got a witness, if I'm going to be asking them questions on a topic that might draw an objection, like I'm going to ask them, hey, what did this other person say? And I know that hearsay's coming. I better have my exception right there ready. You know? And otherwise, well, there's an exception, Your Honor. Well, what is it? Give me a second. Let me, you know, and you got to look it up. If you know you're going to ask the question and you know you want that evidence in from this witness, be prepared for the obvious objections. Okay? And don't get rattled. Okay? And you two, I want to see not just how you respond to objections. I expect you guys to object to what we're doing. Okay? That requires that you're listening. First off, you got to know what some of these objections are, but you got to be listening not only to the question, but to the answer, right? And because your objection could be to the question, your objection could be to the answer. So keep those things in mind, and it happens quick, right? We in evidence last class, we did a little objection exercise, right? And when they had the thing in front of them and they had time to read it, well, here's the question and here's the objection. Yeah, they could identify it and formulate, here's the objection. And they could say it just how they needed to say it. Okay, but that's not how trials happen, right? You're not gonna have it written down in front of you. That person's asking the question, that person's answering, and all you're doing is hearing it. And if you're not hearing it and ready to respond, then, well, they've already asked the next question and got the next answer in, and you're still wondering, what's the objection for that back then? Right, and now you're not paying attention to what's going on right now. You really do have to be on the ball. And the way that you can be on the ball is by being prepared for the trial, right? If you're worried about, okay, what am I gonna do next witness, you're not paying attention to this witness, right? You already gotta know what you're gonna do with the next witness, so you're not worried about that. When the time comes for me to call that witness, I'm gonna flip my tab and everything I need to know and everything I'm gonna need to examine this witness is right there. You can't be thinking ahead, you can't be putting that stuff, letting your mind wander to other things. You've got to be focused on listening as the other side does what they do. And the same thing goes for you, Vince. I won't take all the objections. So, feel free to object, but just know that the way that we have laid it out in the past, and I don't know if the rules say this, but it's kind of the way it works in practice. If it's your witness, you object for, direct or cross, right? I've never had co-counsel on a case myself. I've never had two DAs doing it, but I've been up against two defense attorneys on the other side, and generally that's the way it works. The judge will ask, whose witness is this? That's my witness. Okay, then that person is going to be the one who's objecting. And if it's not your witness and the other person objects, courts will reprimand you. Really? Is this your witness? Like if your partner's missing something, right, you nudge them. You're saying, hey, pay attention.
So you can't both just be like, what if going? What if I don't have questions for this? I'm not sure if I have questions yet. You know what I mean? Like, whose witness is it?
Right.
I mean, it seems
but generally, like I said, whenever I had it, generally that was the way
judges want that.
They want, right? Who's handling this witness? And sometimes it's broken down very broadly, right? I'm handling all guilt phase evidence. I'm handling all penalty phase evidence. Okay, that's easy, right? Or I'm handling all law enforcement witnesses. I'm handling all the expert witnesses. But sometimes it is individual. I'm handling this cop, you're handling that cop, I'm handling this, right? And if that's the way it is, courts want to know. Courts generally don't like objection, okay? And then a couple questions later, oh, objection over here. They generally don't like that. So, you guys should just figure, if it's your witness, either you're the one directing it or you're the one assigned to cross-examine it, that's your time to object. And your role as a partner will be, if you hear something, point it out. So maybe you have your objection sheet open and you point out. My very first trial, I was a law clerk. So as a law clerk, you had to have supervision of a real attorney. And she had a yellow pad and it just said object on it. That's all it said. And she kind of sat in the back of the courtroom. And so I'm at the podium angled at the witness so I could kind of see her on my periphery. And if there was she wanted me to object, she just held it up. The basis was on me. I had to come up with why I'm objecting. She was just letting me know hey, this is objectionable, get ready to say something. So, you know.
It's good training, actually.
Oh, yeah, absolutely. You know.
What is it? What is it?
You know, but I want you guys to kind of keep in mind, just on a very basic level. I know we stressed this, you know, back when you guys took evidence, but all of this happens one question at a time, one answer at a time, one exhibit at a time, right? None of this presentation just happens with, oh, here's a bunch of stuff. That's not the way it works, right? So you have an opportunity on a very small scale to say, that's a bad question, that's a bad answer, that exhibit there hasn't been a proper foundation, there's no personal knowledge, there's no whatever, right? But you get to object to that exhibit one at a time, right? Nobody's going to come in and say, I've got 10 questions, I've got 10 exhibits, and it's all coming in one lump sum. So, you know, I think when you keep that in mind, it gives you, you know, it's like, oh, okay, I can do this, right? But it really is a matter of paying attention, right? And if you haven't planned, let's just assume this is your witness, right? You've directed them. Now I step up and I start cross-examining them, right? If you're thinking about, well, what am I going to do with rebuttal, right? Redirect, or are you even paying attention to what I'm doing? Right? And if I'm directing and you're thinking about, well, how am I going to cross? You're not paying attention to what I'm doing. That's why if you've already got that work done and you're organized and you're ready to go, I know how I'm going to attack this witness on cross, regardless of what you do on direct, then it gives you the freedom and the confidence to sit back and listen and do an effective job protecting your record. So. And you got any questions?
No, sir.
Ready? Will?
I'll try to figure it out. Yeah.
Okay. So we got one more class where we're going to go through and really make sure you guys are at least organized to succeed. And then all you got to do is stand up and deliver, right? That's the key. And there's a spectrum on all sides of that. Right? You got people that can be very, very organized, and they can never stand up and talk to anybody, right? And you got people who need minimal organizations, and they're just good presenters, and they can just stand up and do that. John's a natural, but he's developed his skills, you know, over time. But he can just get up and talk in front of anybody about anything, right? There's no hesitation there. So you get there through experience and time. So, all right, guys, that's all I got. Okay.
Thank you.
Have a good holiday, sir. I won't see you. And you guys as well if I don't see you, which I probably won't between now and then.
All right. Well,
Okay.
Well, we have class this Saturday.
Do you have class on Saturday?
You guys do. I'm not coming.
I have to go. I've already missed 2.
I'm not gonna be here Saturday.
Bye, guys.
All right.
Yeah.
So, yeah.